May I take your lordship's indulgence? My lord, we have filed an application today, writ petition. May come up on Monday, it has some urgency. It relates to the selection and appointment to the post of graduate thesis. We are the first batch of selected candidate on merit, but subsequently they say that because you receive certain documents after the date of submission of the online application, therefore you are rejected. But that cannot be a ground because on the date of verification we have produced everything. On
But if
Monday-
it's rejected, then where's the urgency?
Sorry?
If it's already rejected, there's no urgency, I think.
Because now they are contemplating to bring in the lower on merit persons in our place. Second merit list. We are in the first merit list.
See,
Therefore-
there's already a list for Monday. So
True.
not possible. We may have it on Wednesday, on a motion day.
By that time, my lord, things might change. Again, some new people will come in and some complications will arise. That's why small matter, my lord, lordship may accommodate Monday.
All right.
They
Mm.
may giving the details.
My lord,
Give a memo. Mention
yeah.
memo.
my lord, I am also seeking lordship indulgence to accommodate me, my lord, the item number 15. My lord, I
15.
may be allowed to, my lord, do the case on second half, my lord, at 2, my lord.
Not possible. Second half court will not be available. You do it now.
My
Which
lord,
item you say?
Maybe
Which-
sir for the day, my lord.
Which item?
Item 15, my lord.
Okay, as paid for by Mr. A.R. Sikdar, learned counsel for the petitioner. Matter stands passed over for the day.
May I please, the lordship? I beg to mention item number 11, lordship. Matter may adjourn for the day, lordship. It will be come on 1st of August, lordship. I have taken consent of the.
On the prayer made by the learned counsel for the petitioner and not objected to by the other side, matter stands adjourned to be listed again in the first week of August
First
On
of
a-
August.
on a date to be fixed by the registry.
Here BTC is also your lordship. I am appearing for respondent 1 and
Thus,
2.
learned counsel appears for so and so.
DP
Yes,
organized.
next.
May I please, your lordship?
Yes,
I beg to mention distinct the rate petition for orders column, my lord. Rate petition for orders
approach
column.
the registry.
Lordship, already we have filed lordship in registry lordship, 2 times lordship.
You want matter to be listed for orders? You go to the registry and write it up in the register there. They'll look into it, okay?
May I please, your lordship, may I beg to mention WPC number 3675 of 24
Hmm?
for listing. For listing,
Listing what?
for listing hearing maybe.
You also go to the registry.
Daily list item 1 for motion.
May I please, lordship, my lord, this contempt petition, my lord, the against the order dated, my lord, 28/6/2024,
Mhm.
page 25, my lord. Page 25. Here the case, my lord, this is the second round of the litigation, my lord. The earlier petition approached this court for consideration of the case, my lord, for permission of service. Thereafter, the court directed to the petitioner file an appeal. Appeal was filed and it was placed before the government, my lord. Government directed to the director, but director did not take any step. So I approached this honorable court, my lord. This court directed to place the matter before the director and take necessary action.
Okay, will issue notice.
Yes, my lord.
Heard Mr.
Yes, my lord.
H. Ali, learned counsel for the petitioner, who submits that the direction passed by this court, white order dated 28/6/2024 in WPC number 3321 of 2024 has not been complied with by the respondent, despite a copy of the same having been furnished. Stop. Next para, issue notice, returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondent by registered post with ADDU within 3 working days.
Hello, lordship.
List again after 4 weeks.
Item 2.
May it please your lordship. My lord, this matter relates to compassionate appointment, my lord. The petitioner's husband died on 11/6/2014,
Hmm.
and she applied on 14/7/2014, my lord.
Hmm.
Thereafter, my lord, there were various official communications. Apart from that, my lord, the official communications, nothing was done. Her case was never placed before any DLC, my lord.
Hmm.
So, and in the meantime, his official office memorandum came in, the impugn office memorandum.
Hmm.
And it remained like that, my lord. My limited prayer is only to place the case of the petitioner before the DLC. The DLC may reject if they find she is not eligible.
Mr. Dury?
Lordship, on perusal of that page 26,
Hmm.
it seems that the deceased was a stipendiary teacher, so they have not availed a pension even. So taking that into account, the harness,
Hmm.
it can be placed in the next DLC.
26, you said.
Page 26.
My lord.
Stipendiary teacher, they have not availed their pension. So as they expired on 2014,
14.
so assuming the harness, it may be placed in the next DLC.
At Miss S.B. Chaudhary, learned counsel for the petitioner, and Mr. B. Dury, learned government advocate,
For 1, 2, 3, and 9.
for respondent numbers 1, 2, 3, and 4.
3 and 9, 9 yellow.
Hmm.
3 and 9.
1, 2, 3, and 9. Miss S. Sutia, learned standing counsel, elementary education, appears for respondent number 4 to 9. 4 to 9. No, 4 to 8. Stop having regard to the nature of the grievance projected by the petitioner. The writ petition is taken up for disposal at this stage. Stop. Next para. It is the case of the petitioner that her husband her husband, who was working as a stipendiary teacher in Pokadol LP school under B. Puria Education Block, died in harness on 11/6/2014. And therefore, the petitioner submitted her application for compassionate appointment before the respondent authority concerned on 14/7/2014. The application of the petitioner was forwarded to the Deputy Inspector of Schools, North Lakhimpur, by the Block Elementary Education Officer, B. Puria, on 25/7/2014. Stop. However, the case of the petitioner has not been considered till date. And that, in the meantime, the state government in the personnel within bracket capital B department had come up with office memorandum dated 18/9/2024, wherein it is provided that compassionate family pension scheme will be henceforth introduced instead of compassionate appointment. Stop. Aggrieved, the petitioner is before this court. Next para, it is the case of the petitioner that similarly situated persons whose applications for compassionate appointment was pending were taken up together by this court, and the lead case being WPC number 342 of 2025. Comma, all the cases were disposed of by the common order dated 3/4/2025 by directing the respondent authorities to consider all the pending cases in terms of the relevant guidelines issued by the state government. Full stop. It is therefore the case of the petitioner that our case is also pending consideration, and that the petitioner has not availed the compassionate family pension. Full stop. Next para. Having perused the materials available on record, it is seen that the case of the petitioner is also similar to the case of the others. Who were given the benefit of consideration by the district level committee concerned. Full stop. Accordingly, the writ petition is disposed of by directing the respondents, more particularly, by directing the respondents to consider the case of the petitioner in the next DLC meeting. For compassionate appointment. Anything else to be observed? I said disposed of. With petition accordingly stands disposed of.
Deeply obliged.
Item 3.
So this is also relating to compassionate appointment, and Lordship, by order dated 23/6/25, it was directed to obtain the instruction whether the case of the petition was placed before the SLC or not, pursuant to the DLC dated 7/8/24. DLC has recommended.
DLC is recommended.
Yes.
So question is whether it was placed before SLC.
If not, then my case may be placed, Lordship.
Yes, yes,
It can be placed.
yes. Also, it's a case of 18/3/17.
DLC page 21, relevant serial number 4, Lordship. Page 22.
Heard, Mr.
S.U. Ahmed.
What side was it?
S.U. Ahmed, learned counsel for the petitioner, and Mr. B. Diori, learned government advocate,
I'm for 2 and 3.
for respondent numbers 2 and 3,
1 and 5.
and Ms. S. Sutia for respondent numbers 1 and 5. 1 and 4. 1 and 4. So, having regard to the nature of the case projected by the petitioner, the writ petition is taken up for disposal at this stage. Next para. It is the case of the petitioner that petitioner is a she, isn't it, lady?
Yes. Yes, Lordship.
Her father expired. No, her father, who was working as an assistant teacher at Kasomari Wheelpar LP School died in harness on 18/3/2017. Stop. The petitioner therefore applied for compassionate appointment before the authority concerned on 12/2/2018. To stop, her case was not considered for a long time, and therefore she submitted a representation on 1/8/2024 before the respondent number 4. And thereafter, the district level committee (DLC) Darang, which met on 7/8/2024, considered the case of the petitioner and recommended her name to be considered by the state level committee (SLC) for appointment as assistant teacher. Stop. However, in the meantime, the state of Assam, the state government, you're right, the state government in the personnel (B) department came up with office memorandum dated 18/9/2024, by which compassionate family pension scheme has been introduced instead of the compassionate appointment scheme. To stop, aggrieved the petitioners before this court. Next para. It is the case of the petitioner that similar other petitions have been filed before this court, and this court White Common Order dated 3/4/2025, wherein the lead case being WPC number 342 of 2025 disposed of the writ petitions by directing the respondent authorities to consider all the pending cases for compassionate appointment as per the relevant guidelines formulated by the state government. Full stop. It is therefore the case of the petitioner that since her case has been recommended by the DLC Darang, her case may be placed before the SLC for consideration. Next, upon perusal of the materials available on record, it is seen that the case of the petitioner is also covered by the earlier decision of this court. And accordingly, the respondents are directed to place the case of the petitioner before the next SLC meeting for consideration of our appointment on compassionate basis. Anybody would place it before him, the SLC?
Lordship, that DLC will forward and the same will reach the SLC automatically. The mechanism it is so.
The respondent number 3
Yes.
and 4, correct? DLC and the district DEO,
3, Lordship.
respondent number 3 shall do the needful for placing the case of the petitioner before the SLC. With the above observation and direction, writ petition shall be spoken.
Madam.
4, 5, and 6.
These are
May please, Your Lord. On last occasion, Your Lordship, instruction was sought for. The case of the present petitioner is like this, Your Lordship. The petitioners, Your Lordship, pursuant to an advertisement. Your Lordship will get it.
Mr. Botakur, just a minute.
Lord,
Let me read.
Lord.
Yes, wait.
It is.
It had.
Yes.
Lordship, I have received instructions yesterday.
Hmm.
So I need 2 days to file the affidavit. Then Lordship may take up the matter for final disposal itself. Instruction we have-
Difficulties, Your Lordship,
It will take some time for verification is going on.
Hmm.
So next week, maybe Thursday, Lordship may take up the matter for final disposal.
if Your Lordship, new incumbents, they call Your Lordship, third party right will be accrued. That's the.
Then
that we
Lordship may
have-
hear it for the interim pair.
Lordship.
I have all the judgments also, I'll argue, no problem. But the instructions as my learned friend started, that instruction was sought for.
No, that
I
is
received
not-
instructions. This is the instruction dated 22nd and I received yesterday. We are preparing the affidavit. By Monday, we'll file the affidavit. If they want to give reply also, they will have 2 days. If Lordship is pleased to take up the matter on an urgent basis, Lordship, then on Thursday next. Because for interim also, for final disposal, same hearing has to be done.
Hmm.
On the sole question that whether after the last date of submission of application, if someone acquires the qualification,
Hmm.
whether that is admissible or not. And what they have stated in the affidavit petition, that on earlier occasion you allowed, that is a totally incorrect fact. That is why affidavit is very much essential.
So far as Your Lordship, that statement is concerned, we have come up with a document also, Your Lordship, which clearly reveals that they have, Your Lordship, allowed people to submit the diploma certificate even after, Your Lordship.
Okay,
verification.
okay. What is the process now? How long will this process go on?
So huge
That-
now large number of candidates, we are going through the verification process.
Hmm.
But I can assure this honorable
Hmm.
court that till Thursday or till next 10 days, nothing is going to happen.
That observations from the learned advocate general may be recorded, Your Lordship.
So we'll take it up on Thursday.
Thursday, Your Lordship.
Before that,
Or if on Tuesday also.
Hmm.
I am
Tuesday
ready
it
for
will
that.
be difficult because if they come up with an affidavit, Your Lordship, you may
We
have
can
to-
give an advance copy tomorrow itself to the other side. If there is
Tuesday.
urgency on their side, we are not in
Tuesday.
a urgent,
We have urgency, Your Lordship.
we are not in urgent mode. But
Okay.
still we are cooperating with the other side.
You can file affidavit by which date? By Monday.
Tomorrow we'll give an advance copy to the other side.
Hmm.
And by Monday, because tomorrow, if the registry is open, then we'll file it tomorrow itself.
Tomorrow's not a working day, I think.
And then
Hmm.
Monday, 10:30 we'll file the affidavit.
Okay.
But advance copy they will receive tomorrow. They can
Monday,
prepare
let
that.
them file on Monday, we take it up on Thursday.
Lord,
In the meantime, you may file a reply if you want to.
Another pertinent question in this matter is that we are qualified under the central law and the state law. Now, when the central law and the state law occupies the field, whether the state can prescribe qualification.
Okay, this is, leave it for the argument day.
Yes.
All these things will be considered.
But in any case, my verbal instruction, the appointment will take place sometime in the month of October, not now.
Hmm. Okay,
But let this system timeline remain, Lord.
please write, parties are represented by the respective councils. Mr. D. Saikia, Learned Advocate General, Assam, submits that he has received the instructions and that counter affidavit will be filed by Monday. By date? By 28th of 2025. 28th of July, 2025. Mr. S. Borthakur and Mr. BP Bora, Learned Counsel, appearing for the respective, appearing for the petitioners, submit that there is urgency in the matter because a third party may be created in the meantime if there is some delay. To stop, Mr. D. Saikia, Learned Advocate General, submits that appointments will only be, submits that the scrutiny is going on and therefore appointments and therefore making appointments will take time. To stop, he submits that only appointments would probably take up, appointments would be made only sometime in the month of October. To stop, be that as it may, since urgency has been expressed, let the counter affidavit be filed by Monday, give the date, and the matter, whereafter the petitioners may file rejoinder affidavit if so advised. To stop, as agreed to by the parties, list this matter on Thursday. Please give the date.
briefly applies.
Date
31.
30%. Highly applies. Lord.
So this will cover item number 4, 5, and 6.
4, 5, and
12.
4, 5, and 12.
4, 5, 6, and 12.
4, 5, 6, and 12.
And 12. Yes.
Item 7.
Lordship, in this case, petitioner is a assistant teacher in upper primary level, Lordship. Lordship, on 2/9/2024, Lordship, he was appointed as assistant teacher in upper primary school and he was posted at Bagwan Girls High School, Lordship. And next are 1, Lordship, page 13, Lordship. Thereafter, Lordship, on 3rd October 2024, Lordship. Another Lordship corrigendum was issued, Lordship, wherever his place of posting was modified, Lordship.
This is what, transfer posting?
No, Lordship.
What is your grievance?
Lordship, my grievance is that my place of posting is Kurwa Bhasa MV school, but I was allowed to deploy in another school, Lordship. So as per RT, Lordship, as per the pupil teacher ratio, Lordship, the deployed school is higher than the permitted under the RT Act, Lordship, and the basic school is suffers low, Lordship. Now, already, Lordship, I have submitted representation, Lordship.
Where is your representation?
Lordship, page number 18, Lordship.
Representation.
Two representation, Lordship.
Probably their objection there. Whatever, right. Then transfer over.
Where is your deployment order?
Lordship, page number 15, Lordship.
15.
15 is type copy.
Your place of posting is?
Purva Bhasa MV School.
Okay. Now,
Earlier, my place of posting was Bhagwan Girls High School, Lordship. Though my place of posting was modified, but I was deployed to work at earlier school, Lordship, Bhagwan Girls High School.
why is that?
Lordship,
Why?
Lordship, in this regard, I have no knowledge, Lordship.
Corrigendum, write this corrigendum,
Lordship.
your posting has been modified
Yes, Lordship.
from Bhagwan Girls High School to Kurwa Bhasa.
MV School, Lordship.
But still you're working in Bhagwan Girls.
Yes, Lordship.
How is that?
My only prayer is, Lordship, kindly allow me to work in my place of posting, Lordship, in best school, Kurwa Bhasa, instead of, Lordship, Bhagwan Girls High School. Already I have submitted 2 representations.
These schools are nearby.
Lordship, distance about not nearby, Lordship. More than
My lord, I will take instruction now. My lord, this ordered corrigendum order is of my lord, the 3rd October 2024.
Page 15.
Is right. The grievance of the petitioner is that he has not been allowed to work in Kurwa Bhasa MV school.
His original appointment place of posting is Madam Bhagwan Girls High School.
In terms of the modified place of posting, white corrigendum dated 3/10/2024. So Mr. P.K. Bora, Learned Standing Council, Elementary Education, to obtain instructions by the next date. Stop petitioner shall furnish us an extra copy of the writ petition to Mr. P.K. Bora to enable him obtain the instructions. List the matter again on so and so.
I'm appearing for respondent number 2.
Which date? When can you get the instructions?
2 weeks time maybe gentlemen.
Give a date after 2 weeks. On 18/8. Ms. P. Das, Learned Standing Council. Higher education, is it?
Secondary one.
Secondary education.
Second.
Appears for respondent number 2.
Yes, sir.
God bless you.
Thank you.
Item 8.
May I please, Your Lordship? May I please, Your Lordship?
Yes.
Your Lordship, my senior is on legs in court number 1 in item 8. So kindly pass over the matter for the time being.
What is the prayer?
Where my lord is to set aside and quash the impugned order dated 31/2021, where the petitioner was appointed as tutor.
Which is the impugn order that you have challenged?
My lord,
Impugn order,
31/2021.
page.
Here he challenged the accommodation. As a
My lord, page 81.
81. You're challenging the accommodation as tutor.
Tutor clause, my lord, the accommodation tutor will not get the past benefit. Is, my lord, selling that clause, my lord. At this time, my lord, notice may go. My lord,
See,
here-
I think there were other similar cases also, isn't
my
it?
lord, yes.
Some irregular appointments.
My lord, they are
They were adjusted as tutors.
tutors,
This is also one of those cases.
my lord. Here, my lord, this petitioner have been appointed as accommodated as a tutor. My lord, he is claiming his past benefit now, my lord.
What is your good name?
My lord, SK Lahan.
Hmm?
SK Lahan.
Heard Mr. S.K. Laskar, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the order dated 31/2021. By which the petitioner has been accommodated as tutor in LP/UP school purely on temporary basis on a fixed pay. Next para. In view of above, issue notice of motion returnable by 4 weeks. Mr. P.K. Bora, Lanet Standing Counsel, Elementary Education, accepts notice on behalf of
Respondent 1 to 4, my lord.
respondent numbers 1 to 4.
Respondent 5.
Miss R.M. Barua, Lanet Standing Counsel, Finance Department, accepts notice on behalf of respondent number 5. Notice is complete. Petitioner to serve requisite copies of the writ petition to the learned counsels appearing today within 2 days. List the matter again after.
Obliged, my lord.
4 weeks. On a date to be fixed by the registrar.
Item 9.
Mayor, please, your lordship. Lordship, kindly pass over the matter for the timing, that my senior will be appearing in this matter.
What is this matter? You do it.
Lordship, in both the matters, our senior will be appearing. Please kindly let see board number 1.
Which board matters?
Lordship,
Eight
item
and
number
nine.
8 and 9, Lordship.
8th, we have already issued notice. 9 also, what you have challenged? Item 8, na, you also write one more line. Also issue notice on the interim prayer,
Yes.
returnable by 4 weeks. Heard Mr.
SK Lahan.
S.K. Lakhar, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent authorities to treat the
Verification.
services rendered by the petitioner as qualified service in order to enable him get pension under the Assam Services bracket pension close bracket rules 1969. To stop, the petitioner has also sought for a direction to the respondent authorities to allow her to withdraw the GPF amount Next para, issue notice of, in view of purpose, issue notice of motion returnable by 4 weeks. Mr.
PK one.
P.K. Bora, other standing council, elementary education, accepts notice on behalf of respondent numbers
1 to 5 now.
1 to 5. And Miss R.M. Bora, RM accepts notice on behalf of respondent number 6. Notice is therefore complete. Petitioner to serve requisite copies of the writ petition to the learned councils appearing today within two working days. Also issue notice on the interim prayer, returnable by 4 weeks. List the matter again after 4 weeks on a date to fixed by the registry.
God bless you.
Item 10.
May I please, your lords?
Yes.
My lord, the petitioners claim before my lordships and prayer is for the, my lord, his pensionary and other benefits, my lord. My lord, it's a peculiar situation has arisen, my lord. The petitioner was initially appointed in the year 1996, my lord. My lord may be pleased to find my order of appointment is at page 22, my lord.
This is a second round,
My lord, in fact, 1, 2, 3, 4, 5th round, my lord.
5th round.
Went to Apex Court also, and there is an order, my lord, of the Honorable Apex Court. My lord, to cut short, my lord, if my lordship permits me, my lord, notice is required in this case. My
Yes,
lord.
what is your claim?
My lord, claim is the retirement benefits, my lord, retirement benefits. And as I have been
You retired as what?
retired as, my lord, lower division assistant, my lord.
LDA.
LDA, my lord. in
Where,
the,
from which
office-
establishment?
Office of the, my lord, District Elementary Education Office, Hailakandi, my lord.
Okay.
My
So
lord.
then why are you not getting pension?
My lord, actually, my
Some
service-
proceeding was done.
Yes, yes, not proceeding only, my lord. I had been, my lord, terminated also in the midway of my service. And even after the termination, my lord, I have been allowed and continued to work for more than 17 years, my lord.
After termination.
After termination, my lord. And my lord,
It's
thereafter, my lord,
It's
thereafter,
a unique case, huh?
my lord, unique case, my lord. Thereafter, my lord, this petitioner approached before my lordships, my lord, with the challenge made to the termination order, my lord. That writ petition had been dismissed and matter had been assailed to the division bench, my lord, and the honorable division bench had also upheld the learned single judge's order, my lord. Then the matter went to the Apex Court. Apex Court, without interfering, gave a very narrow observation. I straight away draw my lordship's attention to that SLP order at page 79, my lord.
Now, what did the single judge say?
My lord, the single judge says that the termination was, my lord, very legal, my lord, and in fact, some discrepancies were also found, my lord, in his.
Termination was set aside.
My lord.
Termination was set aside.
No. Termination was not set aside. Termination was upheld, my lord.
Upheld.
Upheld, and the division bench has also upheld the
Upheld.
termination, my lord.
Then Supreme Court.
Supreme Court has, my lord, in the page 79, my lord, annexure 19.
Hmm.
However, my lord, my lord got it, my lord. Page
Yes.
79, my lord. We find no reason to entertain this special leave petition, which is accordingly dismissed. However, the petitioner shall be paid wages for the period he actually worked, and there shall be no recovery.
Hmm.
Pending application shall stand disposed. So, my lord, basing on this, my lord, observation of this honorable Apex Court, my lord,
Hmm.
I am entitled to the benefits, my lord, of my period of service which I have rendered. Now, my lord, rightly, wrongly, my lord, I have to submit fairly before my lordships, my lord. Although there is a termination, but the department never prohibit or restrain me from discharging my duties. More surprising, my lord, is that after the termination, the sequence of events, my lord, if my lordship may be pleased to take up, my termination order, my lord, is at page, my lord, 38.
Hmm.
Not the operative part is at page 39. Hence, the ad hoc service of the petitioner cannot be allowed for continuation, and henceforth the petitioner service are hereby terminated with immediate effect. The District Elementary Education Officer Hailakandi is hereby directed to take immediate necessary action to release the petitioner from his service as LD assistant. Now, my lord, may kindly say, this is an order issued by the director addressed to the district elementary education officer, my lord. Now, the district elementary education officer ought to have complied with this order, my lord, by releasing me, but what they have done, my lord, may kindly turn to page 42 annexure 10, my lord. They allowed me to continue, my lord, in my position, my lord, and this EP, my lord, has also been allowed to be crossed by, my lord, by fixing my salary as a regular employee, my lord. Page 42, my lord, may kindly have a look, my lord.
You were allowed to work on ad hoc basis.
My lord, that continuation was continuing, my lord, and in, my lord, page 44, my lord, even the various works had also been assigned, my lord. I am
42, what is the date?
my lord?
42,
Page number 42, my lord.
There is no date.
Is the date 6/10. My lord, 6/10/2000, my lord, I'm sorry, in the type copy, we have not put it, but in the original at page 43, my lord, may be pleased to find.
610 what? Which year?
6/10/09, no?
09.
6/10/2009, my lord. It's written in the memo also, my lord. My lord, may kindly turn to next page 43, my lord. In the below, my lord, it is 6/10/09.
Yes, I've got it.
Yes, yes. So, my lord, thereafter I have been allowed to continue, my lord, and various orders, even in the name, in the gradation list, my name has also been incorporated for the purpose of promotion to the next post of senior assistant, my lord. Thereafter, my lord, I have been assigned with the various works, my lord. If my lord may be pleased to take up only one order, my lord, is at page 56. My lord may be pleased to find is at page 58 is the name of the petitioner, my lord. I have been allowed this designated with these works also. So, my lord, I have been employed and my service has also been extracted. That's why, my lord, the Honorable Apex Court, my lord, by considering, although it is not a detailed judgment, but it has been observed, my lord, that the period for which my service has been extracted or, my lord, been benefited, my lord, I am entitled to the benefit, my lord. So
Okay, will
therefore,
issue notice.
my lord,
Will issue
my lord.
notice. Heard Mr. A.R. Bhuyan, learned counsel for the petitioner, who submits that the case of the petitioner has a checkered history. To stop the petitioner, although terminated from service, from the post of LD assistant under the establishment of respondent number
Respondent 3.
3,
The district elementary education.
continue to be employed. And for that reason, the petitioner, by filing this writ petition,
Only 5, no?
is seeking direction to the respondents to release him pension and other retirement benefits. Next para, issue notice of motion returnable by 4 weeks. Mr. P.K. Boral and its standard council, elementary education. Accepts notice on behalf of respondent
1,
first.
3, 5 and 6, madam.
1, 3, 5 and 6.
Madam.
Is R.M. Boral and its standing council, finance department.
Correspondent 2 and 7.
Accept notice on behalf of respondent numbers 2 and 7. Then 4,
B Devi,
Mr. B. Deori, learned government advocate, accepts notice on behalf of respondent number 4. Notice is therefore complete. Petitioner to serve requisite copies of the writ
My-
petition to the learned councils appearing for the respondents within 2 working days.
My lord, I was working in the establishment of respondent 5, my lord. I have wrongly said it is 3. It should be 5, my lord.
Just correct it. Respondent 5.
Obliged, my lord. Highly obliged.
13,
Yes.
Well, in this case, my senior S. Botaku is will supposed to appear, my lord. He left the court, my lord, suddenly due to some urgency, lordship. They have paper on Monday, lordship. There is an urgency in the matter to interim order, lordship. So on Monday, lordship.
What is the case?
Regarding the disciplinary proceeding, lordship.
What is the urgency?
Well, there is a interim order because my lord DP is outside the my lord rules, lordship. By violating the my lord manual and rules.
Did issue notice
My lord, notice, my lord.
on both the interim also and the main case also?
Can you on Monday, lordship? Monday, my lord, he will address, lordship. Therefore, otherwise, my lord, notice.
I may be allowed to take instruction whether
Monday,
the DP is initiating or not, my lord.
DP initiative by.
And my lord, as per the verbal instruction on 9/6/2025, his suspension order was extended. So, my lord, some also time may be allowed to
On
take our
Monday,
instruction,
Monday will not be defined.
or maybe on Monday.
Monday instruction.
Where is on Monday?
He was here, lordship. He has appeared in item number 4 to 6, lordship. But suddenly some urgency, lordship, he left the board. The second half he will come, lordship. Second half, my lord, otherwise my list will be over. Therefore, my lord, on Monday, lordship. Otherwise, lordship. Second half, my lord, list will be over. He will not come. Lordship, on Monday, lordship.
Okay.
Nothing will happen.
On Wednesday.
Wednesday. Wednesday. Monday, there's already a list. Wednesday.
Then what, Thursday? Thursday, lordship.
Thursday can be hearing the.
It's a hearing date, Thursday.
Lordship.
Thursday is a hearing.
Wednesday.
Why not Wednesday?
Wednesday.
Any problem?
Lordship.
As paid for by the learned counsel for the petitioner list again on Wednesday.
37.
DPW.
For orders, item 21 and 22.
Please, your lordship. In this case, my lord, I have filed an IA for implementing of the implementing of an incumbent we have recently joined for the post of Registrar Guwahati University, my lord. So that is in filed yesterday, is not on record, my lord. And I'm also going to file an objection, my lord, on the affidavit that I have filed today, my lord. So may I pray, my lord, this matter may be taken up along with those IAs and the objections, my lord, after.
Mr. G. Alam, learned counsel for the petitioner, submits that he has just filed an application for implement of new incumbent holding the post of
Holding the post of Registrar Guwahati University, my lord.
Registrar Guwahati University. He further submits that he may be given some time to respond to the counter affidavit filed by the.
I'm going to file today, my lord. On affidavit, what they have filed, my lord, on that, my lord, I am filing my objection, my lord, today. And I have also
Okay.
filed one IA, my lord.
Then that
today,
line you
yesterday.
can say. He also submits that he has also filed an objection to the counter affidavit filed by the respondents. It is, however, seen that the IA as well as the objection is not on record. The registry to verify and connect the same to the case and list the matter again when
2 weeks, my lord.
after 2 weeks on a date to be fixed by it,
Obliged, my lord. Most obliged.
along with the IA.
Obliged, my lord.
23.
May I please, your lordship?
Lord will take up this matter along with 32. Because there is a review also. Yes,
The last occasion, my lord. Lordship.
item 32 is the review. Lords will take both together, my lord. This is connected with 32. 32.
Against the order, he has filed a review application.
23 and 32.
No, I am appear for that contempt application, my lord. The last occasion, my lord.
Yes.
23, my lord, the contempt matter, the last occasion, my lord, what's my lord, troubling your lordship mind is, my lord, the application has been filed by under Article 150. And lordship has observed that because of the limitation, this petition is not live. But what I get it from the law, my lord, because it is an application under Article 250. This is a plenary power. And our High Court has stated that if application filed under Article 215, my lord, in that case, my lord, there is no functional limitation. I'll produce that decision, my lord. And lordship heard that this is our constitutional power. Can I act, my lord, taken out of power of the constitution, my lord? I filed an application under Article 215, rate with Section 12 of the Contempt Act. The plenary power, my lord, Article 215, my lord. This power cannot be taken away. The court of record, my lord, and the High Court has power to, my lord, punish. And this power cannot be taken.
Nobody is taking away the power. You have to
Lordship,
exercise,
well,
court has to exercise the power within a time frame. That's all.
Section 20 is not coming to play, my lord. And well, I've seen, my lord, here in the definition of the Contempt Act, court has not been defined. Only in the Section 2 of D, my lord, say, my lord, court, my lord, High Court, my lord. High Court of State or Union Territory. And 1995 3 GLR, page 169, this court has said, my lord, in case of, my lord, if petition file under 215, there is no question any limitation. Now, we kindly see paragraph 7, my lord.
Have you given the list of books? That is your copy, isn't it?
Yes.
That is your copy.
Yes, I have the copy. Second copy I have, my lord.
Okay.
I have a second copy I have. Kindly turn to, my lord, page paragraph 17, my lord. Paragraph 7, my lord.
Paragraph 7.
In the paragraph 7, my lord. Has your lordship got it?
Yes.
In the affidavit in opposition filed on behalf of the contender, it is stated that the petitioner was reinstated in service. The order passed by this court was complied with, and the management of the same date by same order terminated the service of the petitioner, and the management has such right. In the whole affidavit, nowhere is even a single line seeking the apology, rather than the contender has tried to justify his action. So we are only concerned with the justification put forward by the contender. Mr. Khetri raises the three preliminary objections regarding the maintainability of the contempt petition. First, that this contempt petition is barred by Section 20 of the Contempt of Court Act 1971. In as much as under Section 20 of the Atrocity Act, the period is 1 year from the date of the alleged contempt. Be that as it may be, this court can exercise the power under Article 215 of the Constitution, and if this power exercised under Article 215 of the Constitution, the question of limitation is absolutely irrelevant in as much as there is no limitation to exercise the power under Article 215 of the Constitution of India. The plenary power, this order, that power cannot be taken away by the act of the one legislature, my lord.
Give me the contempt of courts act.
Can you see the 215, my lord? Article 215, my lord, of the Constitution, my lord. Every high court shall be court of record and shall have all the power of such court, including the power to punish for contempt of itself, my lord. If lordship exercise jurisdiction under 215, my lord, in that case, my lord, position of my lord, limitation is not possible. Absolutely a plenary power, my lord, and this power cannot be taken away by any act, my lord.
You have the Contempt of Courts Act.
Yes, my lord.
Come to the definition,
Yes, the definition, my lord.
section 2B.
2, my lord.
2B.
It has not been defined, my lord. The
Come to
court-
section 2B,
Yes,
civil contempt.
yes, the High Court means the High Court for state of Union Territory and includes the Court of Judicial Commissioner in any territory, my lord.
No, where are you reading?
Definition of B.
Section 2B,
Yes, my lord.
civil contempt.
Civil
read that.
contempt means willful determination up to any judgment, decree, direction, order, writ of other process of court, willful breach of any undertaking given to the court, my lord.
So writ is also there. Civil is there, criminal is there. Any direction, any decree, any judgment, any order.
Ah.
This is covered by,
Giving to the court, my lord.
hmm.
My lordship troubling your mind regarding the
So
limitation.
it includes the writ court also.
Read court, my lord, read court also.
It includes a writ court also.
Yes, my lord.
So a writ passed by the
Any, my lordship, means
High Court under 226 also will be included.
No, what is the meaning of civil contempt? This is the meaning of the, what is the civil contempt? Means willful disobedience to any judgment, decree, direction, order, writ, or other process of the court, willful breach of undertaking given to the court.
Hmm.
This is the meaning of what is the civil contempt. But my submission before is this, my lord, whether, my lord, this article 215 is barred by limitation under section 20 of the Contempt Act. This is a plenary power, my lord, and the power can, my lord, constitutional power can be taken away by the act of the legislature, my lord. Any act must confirm the provision of the constitution. Here, my lord, it is a plenary power to article 215. That is the reason our High Court has said that this court has said, my lord, if exercise jurisdiction under 215, then questionable limitation will not come.
You don't have any decision of the apex court.
No, my lord, I've seen.
I will hand over, my-
Correction, my lord,
Apex court decision.
regarding the limitation.
Yes, regarding limitation, my lord. Section 214, 215 of the Constitution should be read in consonance with the Contempt Act, my lord. We will straight away go to paragraph. There is a settled decision, my lord. This is no longer eccentric, my lord. There is a decision called Pallab Seth, my lord. Based on Pallab Seth, this has come, my lord. Let's will turn to page number, paragraph number 10. And 14, my lord. And the paragraph, relevant paragraph for the Pallab decision of paragraph 44 has been quoted, my lord.
Pallab Seth.
Pallab Seth, my lord. Pallab Seth.
Pallab Seth is again 2001, 7, SEC.
2007 SCC 549.
So that has been followed in this.
See, all that has settled the issue, my lord. Paragraph 44 has settled the issue, my lord. And 444 has been quoted in paragraph number 14, my lord, in this case. I can hand over that Pallab Seth case also, my lord.
Paragraph 44 means
Paragraph 44, my lord. That is quoted, my lord.
44 in
44.
Pallab.
In paragraph 14, in this case, paragraph 44 had been quoted, my lord.
So paragraph 44 of which?
Second part, my lord, I have highlighted it in our opinion.
This 44 has been quoted somewhere.
Yes, 44 in that. This 44 has been quoted in
Maheshwar.
2015, 14. Yes.
Where? Which part?
Paragraph 14, my lord.
Hmm. Oh, yes.
Yes.
Hmm. You want to examine this aspect?
Yes, my only thing, my lord, another thing, my lord, kindly taken into consideration. The first case was, my first requisition was disposed of on 6/9/2019, my lord. Thereafter, my lord, the second requisition filed on, my lord, the second final on 18/2/2020, and that was, my lord, disposed of, my lord, 16/12/2022. I have, my lord, an order of the 16/12/22. Thereafter, thereafter 12/22/2022, I have informed the Ellis container regarding the passing of the order of this court, my lord. Thereafter, my lord, of 5/7/2003, my lord, that in the last annexure, page 23, annexure 4, the container asked to me, it appeared to before there with a relevant record. And I filed this application, contempt petition, in the month of February 2024, my lord. Even and that case also, my lord, that the remediation is not come, my lord. Shall we see? 5/7/2023, my lord. And at section 23, my lord, 20C, although we use the word, my lord, shall, my lord, in sometime, my lord, word maybe shall, maybe used as not a directory, my lord. It's some that mandatory, sometimes it is a directory, my lord. Section 20, my lord. After all, this is a court order, my lord, to uphold the majesty of the court order, my lord. While they come this plea, my lord. And either this examination, whether that regarding that case, my lord, I have not gone through that case, my decision, my lord. Again, that case, my lord, whether that the point is limitation is taken on or not.
So you examined that case also. We'll
Yes,
adjourn it today.
Yes, my lord.
We'll adjourn it today.
Let's take both the case review also.
Yes,
together.
we'll take together.
Only thing, my lord, only one of the moment, my lord. That is otherwise, my lord, this is not come to limitation, my lord. Or second order passed on 2020. I filed application that was 2022.
You examine the judgment and make a submission next date.
Yes.
You are Mr. R. Barua.
Yes, my lord.
Heard Mr. R. Barua, learned counsel for the petitioner who submits that this contempt petition has been filed for willful and deliberate violation of the court's order dated 16/12/2022, passed in WPC number 3812 of 2020. It is, however, seen that the instant contempt petition is filed on 11/1/2024. After a period of 1 year from the date of the order alleged to have not been complied with. Mr. Barua submits that since the petitioner has also invoked Article 215 of the Constitution of India, there is no delay. No, the question of delay does not arise, since it is an inherent power given to the High Court. In support of his submission, the learned counsel relies upon the case of Ranjit Kumar De versus Shiv Shankar Misra, reported in 1995, 3 GLR 169. Next para. Per contra, Mr. S. Bora, learned counsel for the respondent, submits that the powers conferred to the court under Article 215 of the Constitution of India has to be read in consonance with the Contempt of Courts Act
1971. September 20.
1971. In other words, the learned counsel submits that the inherent power of this court to punish contempt of its order has to be exercised in accordance with the prescription made by the Contempt of Courts Act. In support of his submission, the learned counsel relies upon the following decisions. Number 1, Pallav Seth versus Custodian and others, 2001-7 SCC 549. And number 2, Maheshwar Perry and others versus High Court of Judicature at Allahabad, 2016, 14 SCC 251. Mr. R. Barua, next para, learned. You are a senior counsel.
No.
Learned counsel. Submits that he may be given some time to examine the matter. In view of above, let the matter be listed again on so and so.
Along with review petition number
Along with review petition number
349 of 2025.
149.
349.
349.
Yes, madam. Item number
32, isn't it?
sorry, man, 149.
149. 149 of 2025.
Oh, High Court rules also, my lord, silent, my lord, regarding that, my lord. I have examined that, my lord, yesterday also. Rule is also silent, my lord. Oblige, your lordship.
All right.
24,
Met, Mr. Lordship. Lordship, page 16 is the order of this honorable court dated 9/2/2024. My lord, here paragraph, my lord, page 20. Page 20, my lord, paragraph 12. The direction was given and to complete within 3 months, my lord. As of now, my lord, only more than 5-6 times they have taken time. Page 20, my lord, is the paragraph 12.
Page 20.
Page 20. It starts from page, my lord, 15. 16 is the date of order. 9/2/2024.
Just a minute. Where's the beginning?
Beginning, my lord, page 15.
15.
15. Then, my lord, page 20, paragraph 12.
Please read.
My lord, the page 20, my lord, paragraph 12. The state level scrutiny committee, SLSC, upon consideration of the case of the petitioner in the light of the recommendations made by the district level scrutiny committee to be proceed to recommend the case of the petitioner for provincialization of services. The Director of Elementary Education Assam shall take appropriate steps for implementing such recommendations and provincialize the service of the petitioner with effect from 1/1/2021 with all consequential benefits of pay, seniority, etc. Now, my lord, paragraph 14, my lord, the entire exercise shall be carried out within a period of 3 months. Now, my lord, more than 1 year and 5 months.
My lord, here I am praying for sole respondent. I need some time, my lord.
My lord, my submission is, my lord, the lady may be personally called for, otherwise no instruction will come. Today is 6 times they have, my friend, taken time, my lord. 5-6 dates he has taken. From the director, my lord.
Director. And direction is given to whom? Director only?
Only director.
Director. Sole respondent, my lord. 16/12/2024 time taken, 29/1/2025 time taken.
Just a minute. Okay, just a minute. See, the direction was to place the name before the SLC. And if SLC cannot recommend, they will give a reason order, speaking order. That is the direction, isn't it?
I have received, but that is not complete instruction, my lord. Partial instruction I have received, my lord.
That is the direction, isn't it?
Direction.
That DLC is recommended. So
DLC.
court has said that you place it before the SLC for consideration.
Yes.
Now, if the SLC cannot recommend, then they will pass an order.
It is not for compassionate appointment, for provincialization, my lord. Not SLC, district level scrutiny committee.
Oh, scrutiny committee
Scrutiny committee.
for provincialization.
For provincialization. And my lord,
So either way, they have to take some action, isn't it? Either to allow you or to reject you by a speaking order.
here, my lord, direction is that shall take appropriate steps for implementing, page 20, my lord. Paragraph 12, last line. Paragraph 12, my lord. The state level scrutiny committee, SLSC, upon consideration of the case of the petition in the light of the recommendations.
See, don't stick to one paragraph. The paragraph 12 has to be read along with paragraph number 13 and 14 also. So the district has recommended, the state will consider now to provincialize you. In case they cannot provincialize you, they will have to pass a speaking order.
That
And this has to be done within a time frame. That much only.
My lord,
But they are not doing, my lord.
Now, time is given for 3 months.
3 months now.
Any show cause reply has been filed?
No, man. No, my lord.
Who's the respondent?
Director is the sole
Director,
respondent.
elementary, my lord.
Okay.
Directly.
I have received, my lord, that is not complete
So-
instruction. that
No,
is
it
why-
was
So-
earlier also, my lord, my friends.
The last chance also was given to you already.
my lord.
My lord, actually.
So there's no more chance now.
My lord.
One more last chance, my lord. If I
One
have-
more last chance.
My lord, actually.
Then why not 2 more last chance?
No, my lord, actually, I have
This
received.
will go on and on like that.
My lord, actually, I have received an instruction that, my lord, a review has been prepared to file, but
Sorry?
review has been prepared to file, my lord.
Review.
Review.
Why?
I have to take instruction regarding this, that is.
No,
This, my lord.
that cannot be done.
That is why I'm
Why they
praying
have
for
not done in 1 year, more than 1 year, my lord? This is not fair.
10
my
days time may be granted, my lord, I'll bring up.
Review also has to be filed within a certain time.
To, my lord. 10 days time may be granted, my lord, I'll bring.
No, no, why 10 days time? Tell me. I'll, last chance not given. I thought there was last chance.
15, my lord, 50, on, 19, 19/5. My lord, focus notice is to be given, like I said, because earlier time, my friend also said he has obtained some instruction. Again, today is saying same thing, my lord.
Mr. Bora,
My lord.
see, direction is not to say that at any rate, by any means, you have to provincialize this service.
True, my lord.
Court had observed that in case you cannot provincialize, pass a speaking order.
My lord.
So what is so difficult for passing a speaking order? And how can you speak about review when you have not even filed the review till now?
I have
Order
just-
passed
I have
by,
just received in communication. That is why I have to clarify, my lord.
correct, that communication is not correct. You should advise your client also.
My lord.
Otherwise, we'll have to take proper steps, take necessary action.
That is why I'm praying 10 days time, my lord, I'll clarify it.
You should explain what is the procedure. Once order is passed, only 2 options. You comply, or you file appeal, or you file review. You cannot just sit like that.
Today only I have that, received that communication also.
And now here, after more than 1 year now, nothing is happening.
I'm on the expectation that they will.
And you say that we will file review.
My lord, I'm on the expectation that they will comply, my lord, they will pass in a speaking order. But today when I have received this.
So as a counsel, you have your limitation. So let the director come and explain.
My lord, 10 days time may be
Hmm?
granted, my, I'll, my lord,
Because-
the actually status. my lord.
Court is not happy with the manner in which they are dealing with this.
I'm extremely sorry, my lord.
We'll have to summon her.
Well, 10 days time may be granted, my lord, I'll bring up to date instruction, my lord. Proper.
Not instruction, we want your compliance.
To comply.
My lord,
they
I-
have to
10 days
comply.
time may be granted, my lord.
I thought
Okay.
this last chance, otherwise, my lord, she will appear, my lord. Definitely.
This contempt petition has been filed alleging willful and deliberate violation of this court's direction. Passed white order dated 9/2/2024 in WPC number 6739 of 2023. Full stop. Although several opportunities has been granted to the respondent, but till date, neither show cause notice, neither show cause reply has been filed, nor the engaged counsel, Mr. P.K. Bora, given the instructions. Full stop. Therefore, as a last chance, the respondent is given 10 days time to comply with the court's direction, failing which consequential orders will be passed. Mr. P.K. Bora Lanet, counsel for the respondent, shall ensure that this order is conveyed to the respondent. List again on so and so. 6-8.
Obliged, ma'am. I am deeply obliged.
25 to 31.
May it be pleases you lordship. Here your lordship verification is going on your lordship. And the process will take some time, your lordship. So kindly grant us 4 weeks time, your lordship, as there is a
Okay, what is the direction? Verification for what? It's a case of provincialization.
non-payment of salaries, lordship. The petitioner did not get their salaries since 2021, lordship.
5 to 9 होगा।
What is the operative portion? Yes, madam. What is the operative portion of the order? Which is the order not complied with?
Lordship,
You don't want to assist the court.
lordship, actually, my senior is out of station and I don't have the brief, lordship.
So if your senior is out of station, you take the charge.
But the absence of my senior chamber is closed, lordship.
Order dated 13/8/2024. Twenty-one three. Twenty-four. Okay.
বেশি জানাবে খালি হিতে খালি মর্নিং করেছিল জিয়ে যেন
In 8/24. Covered by 21/3/24. Please write down. This contempt petition is filed for alleging willful, for not required, okay? This contempt petition is filed alleging willful and deliberate violation of the court's order dated 13/8/2024, passed in WPC number 7615 of 2022. To stop the said order dated 13/8/2024 has been passed in consonance with the earlier order passed on 21/3/2024 in WPC number 2757 of 2023. Full stop. Next para, the operative portion of the said direction is that the petitioners would be deemed to be provincialized in their services with effect from 4/1/2021 and accordingly entitled to receive their payment against the post of tutor with effect from that date.
Non-payment of
Stop.
salary.
The Director of Secondary Education, Assam, has been directed to release the petitioners their pay with effect from 4/1/2021 within a period of 3 months from the date of receipt of a certified copy of the order.
Initialized against teacher, no? Against teacher.
Stop. This contempt petition was filed on 9/1/2025 and notice was issued on 6/2/2025. Stop. However, no show cause reply has been filed till date. Ms. P. Das, appearing for the sole respondent, submits that she may be given 3 weeks' time.
I'm appearing on behalf of SMT 60, Your Lordship.
Okay, Ms. P. Das, learned counsel, appearing on behalf of Mr. SMT Chisti, prays for 3 weeks' time. 3 weeks' time. Okay, prays for 4 weeks' time to obtain instructions in the matter. Stop. However, this court is inclined only to grant 3 weeks' time. List the matter again on so and so. Depending upon the instructions obtained by the counsel for the respondent, further orders will be passed by this court. Yes.
Deeply obliged.
How many cases are there? 6 more. Let us complete, no break today.
For admission item 14.
Ask for some hot water.
Your Lordship. The husband of the petitioner has recently expired on 17 July 2025. In this case, Your Honor, the petitioner is the wife of respondent number 6. And the respondent number 6 has expired recently, that is 17 July on 2025. These cases were basically.
Petitioner and respondent number 6 are husband, wife
Yes, Your Honor. And petitioner is the legally married wife of.
of respondent number 6. Why have you filed this writ petition?
This filed case because the respondent number 6 has entered the name of the respondent number 7 to 10 in his service record
Okay.
for pension book, for pension matter.
Okay. Who's respondent number 7?
Respondent
Second
number
wife.
7 is the second wife of.
Second wife.
Respondent number
Okay.
6. And respondent number
Now,
8, 9,
who
10.
has expired?
Respondent number 6 has expired. The husband has
Okay.
expired. Husband of petitioner. The petitioner, the
Okay.
legally married wife of the respondent number 6.
So,
So on the dated on the last date orders 25 to 2025, this honorable court has ordered that no further chance will be given to respondent number 6 to 10 to file affidavit. Respondent number 6 has filed the affidavit, but he has also expired after filing the affidavit. Respondent numbers, the government is also yet to file the affidavits.
so you want to file an application for substitution?
Uh,
Who will represent respondent number 6 now?
Respondent number 6 is we can file an application for substitution. Yeah.
Uh, Otherwise, how will a dead person
Yes, yes.
reply?
Hmm.
When did he expire?
On 17/7/2025.
17/7.
17/7/2025.
Okay, learned counsel for the petitioner submits that respondent number 6, who is the husband of the petitioner, has expired on 17/7/2025. And therefore, he may be given some time to file appropriate application seeking substitution of respondent number 6. In view of above, matter stands adjourned for 2 weeks.
Yes, sir.
You file application, we'll see.
Yes, sir. Obliged.
Question, kindly peruse the order dated 29/11/23.
Just a minute.
Paragraph 11 of the order dated 29/11/23. The council was directed to produce the record. If the record is available, proceed to the hearing matter.
Yes.
A record has not come today, my lord. So next week,
Will come next week.
or after 10 days, my lord.
Matter is very urgent, Lordship. Petitioner only.
My friend has urgency.
What is the urgency?
Lordship, he was upgraded from LD to assistant teacher without violating the rules, Lordship. That is not permissible, Lordship.
Without violating the rules.
Lordship, that is kindly see paragraph number.
What are you saying?
Violating the
Without violating the rules means legal.
Yes, but extra, to give extra weight, she has added the word without, my lord.
by violating.
Upgraded was in violation of the rules. That should be your submission. You are saying that upgradation happened. Listen to me, listen to me. Don't speak while I'm speaking. Your submission should be that upgradation happened in violation of the rules.
Lordship.
Instead, you're saying upgradation happened without violating the rules.
Lordship.
Then where is the case?
Lordship, that is page number, para 14, Lordship, page number 35, Lordship.
Ms. P. Sharma, learned counsel for the learned standing counsel. U. Sharma.
Mr. Yusuf.
Mr. U. Sharma, learned standing counsel for the Secondary Education Department, submits that he may be given further 10 days time to produce the relevant records in terms of paragraph 11 of the order dated 29/11/2023. Stop. Since urgency has been expressed by the learned counsels appearing for the opposite parties, this matter again on so and so. Yes.
In this case, I was directed to file affidavit, Malad. Today itself, I have filed I have served the advance copy, Malad. I'll be filing today during the course of the day. So kindly.
Mr.
S. Das, Malad.
S. Das, learned
Standing Council, Higher Division.
Standing Council, Higher Education.
Let the matter be come up after 2 weeks, Malad. 1 week. 1 week.
Submits that he may be given a week's time to file the affidavit. When are you filing it?
I'll be filing during the course of the day.
Okay.
Or tomorrow, Malad.
Okay, submits that he will be filing the counter affidavit during the course of the day. And that he has served an advance copy to the learned counsel for the petitioner.
Malad, kindly make it, Malad, within 2 days, Malad, for the safe side. By Monday, Malad, by Monday.
Within the course of the day, you cut that. We'll be filing the affidavit within 2 days from today. And that he has served an advance copy to the learned counsel for the writ petition. In view of above, we'll list the matter again after a week.
1 week. Yes.
I am preparing for astronaut 3, madam.
Mr.
S. Mukta.
S. Mukta,
Yes.
learned counsel appears for respondent number 3.
My lord, one date may be fixed first.
It'll come on a date to be fixed by the registry. You add that. They'll fix a date. You might want to file a reply also. We don't know.
Will not file reply. Already I have gone through the appeal.
Okay.
Is not-
One more line. Learned counsel for the petitioner submits that he has gone through the affidavit and he will not be filing any rejoinder affidavit. All right. Next.
May I please, Lord? My lord, kindly see the last order, my lord.
Area salary. How much is it?
My lord,
Have you quantified?
yes, my lord, synopsis with effect from 1/11/2022 to 28/2/2020, 28 months, my lord.
1/11/2020
Yes,
to
my lord.
28/2/2023.
Yes, my lord,
Okay.
28 months.
As what?
Area salary, my lord.
You're working as what?
Tutor, my lord. Tutor, my lord.
Tutor.
Tutor, my lord. Yeah, lord, my lord, kindly see one of the,
Why this salary is not paid to you?
my lord, page 28, my lord. Kindly see the appointment letter of one of the petitioner, my lord.
No, you just answer the question. Why this money is not given to you?
No, my lord, he was appointed, petitioners were appointed, my lord. With effect from, my lord, your lordship, the accommodation order will take effect from 1/11/2020 only, and she cannot claim any benefit whatever in respect of past services rendered by him prior to that period, my lord.
Oh. This is that same category of cases.
Yes.
Here, my lord,
They were adjusted as tutor. There's something wrong with their appointment, initial appointment.
No, my lord, because here, my lord, 87 petitioners are there, my lord.
Hmm.
Maybe they are under the same district, my lord, but blocks are different, my lord. They should come separately, my lord. And my lord, they have only annexed, my lord, 2 appointment orders, my lord,
My lord,
28 and 29.
All of you are working in one school,
Yes.
One
No,
school?
no, my lord.
No, my
Then-
No, one school, in
then-
same district, my lord.
same
Same
district.
By similar order, my lord, they were appointed. Their services were regularized as tutor, my lord.
Where is the order?
My lord, page 28, my lord.
28 is only one order.
One order, my lord. To
What
avoid
about the
bulk-
others?
bulkiness of the writ petition, my lord, I have annexed only one order, my lord.
Why?
That is not disputed, my lord. All the, let them verify whether if the petitioners are
No,
not.
they are under the different block, my lord. 87 petitioner under the different block, my lord.
Different block.
Blocks, my.
Okay.
In all
It
the,
is difficult on our part, my lord, and they have not approached the authority itself, my lord.
You file another affidavit indicating where you're working. Make a table.
if your lordship dispose of the writ petition, directing the petitioner to file individual representation by enclosing all their relevant documents, my lord. That will do, my lord.
Representation to whom?
To the
The director.
comment, my lord.
No, tell me which respondent. Government means what?
Response number 3, my lord, Director Elementary Education.
So can we dispose of in that line? Let them file it.
Individual petition, my lord.
Heard, Mr.
AHMR Chaudhary.
AHMR
Chaudhary.
Chaudhary. Why so long, your name? AHMR Chaudhary, Learned Counsel for the petitioners, who submits that by filing this writ petition, the petitioners seek for a direction to the respondent authorities concerned to pay them the area salaries for the period with effect from 1/11/2020 to 28/2/2023. In the post of tutor. Post of tutor.
Tutor.
Ms. S. Sutia Lanet, Standing Counsel, Elementary Education Department, submits that there are as many as 87 writ petitioners, and that all the petitioners are working under different blocks. To stop, the petitioners, on the other hand, have annexed only the appointment order of the, who is he? Manashinath? Which number?
Petitioner number 2, my lord.
Appointment order of petitioner number 2 only.
Two and 6, my lord. Halma Sinha, page number 29, my lord.
Okay, 2 and 6, okay. Petition numbers 2 and 6 only, then. The learned counsel for the petitioner submits that the petitioners may be allowed to approach the respondent authorities. That is respondent number
3, my lord.
Three, my lord.
No, you rewrite that again. The learned counsel for the petitioner submits that the respondent number 3 may be directed to consider to release the area salaries of the petitioners within a time frame. To stop, considering the prayer made by the petitioners, the writ petition is disposed of by directing the petitioners to submit individual applications to the Director of Elementary Education, Assam, respondent number 3. With their specific claim for area salaries. within a period of 15 days from today,
1 month, my, because there are number of petitioners.
or within a period of 1 month from today. Full stop. The respondent number 3 on receipt of, no, you cancel that. In the event such application is filed by the petitioners individually within the prescribed period, the respondent number 3 shall consider the same and make necessary verification. And if it is found that such the salary has not been paid, take necessary steps for payment of the salary to the petitioners within a period of
3 months.
3 months from the date of receipt of the representation. The petition stands disposal. All right.
Problem.
Well, this is a case where the prisoners are working as agent teachers since 2000. Since mostly 2001, Milord. But they have not been paid salaries, Milord. They were paid for salaries for some period,
What is your claim here, Mr. Chali?
my lord.
What is the prayer?
There is no for regulation and payment of salary, my lord.
Regularization
My lord.
and also salaries.
My lord. Area salary. I've given a list at annexure 15, annexure M, my lord, wherein similarly situated persons at page 76, from page 76, you're also find from
Yes, who's appearing for the other side?
My lord, here we have received instruction, my lord, we will file affidavit.
You have received instructions.
Yes.
When are you filing it?
Within 2 weeks.
2 weeks. Let them file. He has received instructions, it seems.
But on similar matter, my lord,
That,
there is already an order, my lord. I have annexed that
What is that
page
order?
92. And against that, government went to the appellate court. Appellate court also confirmed that position. Let them file affidavit, my lord. Let me.
Okay. Mr. DP Chaliha, Learned Senior
Let me
Counsel,
also complete
appears,
date. My-
assisted by Ms. M. Roy, appears for the petitioners. Mr. G. Pegu, Learned Standing Counsel, Elementary Education Department, submits that he has received the instructions and he may be given 2 weeks' time to file the counter affidavit. Prayer is allowed. List again after 2 weeks on a date to be fixed by the registry. Let counter affidavit be filed on or before the next date.
Fix a date, my lord. Otherwise.
Mr. Chalia, they'll fix a date. I've said to fix a date after 2 weeks, you'll get a date. All right?
Item 20.
Sir, Lordship. Lordship, the matter involved in the present petition is the suspension of the petition.
You are still under suspension.
Yes, Lordship, he was suspended a year back, Lordship, annexure.
Yes, what is your instruction?
My lord, departmental proceeding is going on, my lord. And his suspension was reviewed.
When?
3 times. First on 29th November 2024, my lord. And second one is 27 February 2025 and third is 3rd January. So,
Was it reviewed within time?
yes, within 3 months.
Within 3 months.
You have the review orders.
Yes.
You file it. Give him a copy, you file it. We'll consider it. Let's see. Mr. G. Pegu, Learned Standing Counsel, Elementary Education Department submits that according to instructions received by him, the departmental proceeding is going on and that the suspension of the petitioner has been reviewed on 3 occasions. Full stop. In view of above, Mr. G. Pegu shall file the instructions as received by way of an affidavit within a week from today with a copy to the other side. Okay,
Lordship may fix a date. Lordship.
list again.
Hold on, sir.
List again after 10 days on a date to be fixed by the registry. They'll give a date.
Obliged.
Obliged.